have lost a will, now if you've lost your will and you're still alive, not a problem. You can just redo your will and sign it over. However, if you have lost the will of somebody who has died, whether the person died in the disaster, the same disaster that caused the will to be lost, or they died and you're holding the will for whatever reason, here are the steps you need to take. Always have a copy, a photocopy of the will somewhere else. What I do with my clients is when they are preparing their wills, we give them a copy for them to keep, which is an original sign for them to keep, and we keep a mirror copy in our fireproof safe, so that if anything happens to the original that we give them, there's a backup. I say have a plan. Even if it is not the original, that you don't have a what we call a wet signature copy secured somewhere else, a photocopy secured somewhere else is good enough, because that is what I want to go to next. If a will has been lost and the person is already dead, a photocopy of the will can be used to actually apply for probate in the estate, because you can apply it to the Supreme Court explaining the circumstances that yes, we had the original, but there was a flood, Hurricane Melissa came and took off our roof and all our belongings were lost, and this was a circumstance under which it was lost. However, we did maintain a copy. A copy was kept elsewhere, right? Photocopy, and this is a photocopy, and the person who had the photocopy makes a statement in an affidavit to say, yes man, the testator before he or she died said, hey man, Bill, I wanted to hold a copy of my will, and that is how I came to hold it, and I kept it in this place. Once you're able to prove that it is a valid copy of the original will, the court will grant an order allowing you to use a photocopy for admission to probate.